question you'll ever get from a client in all the days of your life. Question, hey, the police are here. They want to talk to me. What should I do? Well, I could give you my answer to that question in case you haven't already guessed it. But why don't we go to a real expert? Justice Robert Jackson, a prosecutor's prosecutor. Like me, he began his private practice in Buffalo, New York, years before I did. And after that, he served as general counsel for the Bureau of Internal Revenue, the U.S. Department of Treasury, the Security and Exchange Commission, Assistant U.S. Attorney General for the Tax Division, later the Solicitor General and the Attorney General of the United States, and then the Chief U.S. Prosecutor for the Nuremberg trials. That's an impressive resume. Years later, when he was a justice on the Supreme Court, Justice Jackson stated, quote, any lawyer worth his salt, today we would say his or her, will tell the suspect, his client, in no uncertain terms to make no statement to the police under any circumstances. There's the title of my talk. I'm here to explain to you the surprising and somewhat counterintuitive and admittedly unlikely reasons why Justice Jackson was right. I'm reminded of this because I'm amazed. We're all amazed by the frequency with which we see newspaper articles coming on all the time from people who really ought to know better, who say, well, I'll talk to the police. I mean, after all, I'm a senator. I'm O.J. Simpson. I'm an experienced, highly polished individual. I've got a lot of experience with public relations, even criminal defense attorneys. There was a local news story here in the Virginia Pilot just a couple of months ago about an experienced criminal defense lawyer who ended up getting convicted of criminal assault because he talked to the police. He was accused of having assaulted another attorney in the hallway. There were no other witnesses to this. A woman said that he grabbed her by the throat during an argument over a case. He denied it. At trial, it was his word against hers. He said, I did not even touch her. But unfortunately for him, when the police had approached him earlier and said, would you be willing to answer some questions? He said, sure, why not? I'm an attorney. I'm a criminal defense attorney. I'm savvy. I'm sophisticated. I've got oratorical prowess. I'm accustomed to dealing with the police, by all means. And then there was a conversation that was not recorded. When the case went to trial, it was no longer his word against hers, because when he testified at trial, I never touched her, the officer took her to the stand and testified, well, when I met with him, he said he did put his hand on her throat, but just as a joke. Then he had to take the stand again and say, that's not true. I never said that. I never admitted to you that now it's his word against two people. Who's telling the truth? We'll never know for sure. But he was found guilty. Now, here's part of the problem. The heart of the problem, as Justice Breyer on the U.S. Supreme Court explained in 1998, is, quote, the complexity of modern federal criminal law codified in several thousand sections of the United States Code and the virtually infinite variety of factual circumstances that might trigger an investigation into a possible violation of the law make it difficult for anyone to know in advance just when a particular set of statements might later appear to a prosecutor to be relevant to some investigation. One expert on criminal law recently noted that estimates of the current size of the body of federal criminal law vary, although it has been reported that the Congressional Research Service can no longer even count the current number of federal crimes. That's right, even the federal government has lost count.